year. It's nice to see you. Was it for the treatment? Yeah. I was gonna say. After that, for petition. But it's good. I mean, it's not fun. I had to do some of my own stuff too last year. Yeah. Yeah. And that's what's happening. Yeah, really, but I still need someone. Yeah. Purple. Oh, I've only heard little tidbit updates. Yeah, oh, for sure. For sure. Right. I love your earrings. I'm like, sorry, I'm always
Well,
like,
I think we're gonna get this going here. I thought we would start off by just introducing ourselves. Alicia, I am the director of equal opportunity and the Title IX coordinator here at school. Yesterday completed my 4th year at UM. Not that I'm not. Feels longer. And just a little bit about me. I graduated from law school here in 2011. Prior to joining UM, I was in private practice as an employment attorney primarily, who did a lot of discrimination and sexual harassment work. I have 3 little girls here in Missoula, and I'm very committed to UM and to the topics of equal opportunity and Title IX. And I really appreciate diversity taking on this topic for its programming this year. And I look forward to, throughout several of these panels in the next few days, really sort of exploring more about, where Title IX has been as a statute, where we are today, and sort of the challenges that we face, and then sort of preparing for the next 50 years of Title IX. And I just also want to mention that, 50 years ago, in June 22nd, 1972, Title IX was passed into law as a federal statute, and from its inception, it was designed to be an access statute. And I think what we've seen over the last 50 years really is kind of an evolution from access to an equity pursuit in higher ed. And so I think one of the challenges is to continuously utilize a statute to meet the evolving needs. So again, thanks to Diversity for taking this on as a topic.
Hi everyone, my name is Hilly McGahan and I am the Associate Director and the Deputy Title IX Coordinator. I am from Arley, and I did my undergrad here, and then I left for law school and came back. And before starting to work at UM, which yesterday, Alicia and I strangely have the same work start anniversary, but mine's just 2 years. But I spent about 8.5 years practicing up in Lake County on the Flathead Reservation, doing domestic and sexual violence civil legal services. And I too am excited to be here with you all today. It's been a really interesting experience for me to go from doing my prior work to kind of working on similar things, but in a really different context, and understanding kind of higher education and how Title IX has evolved and applies. And so I'm looking forward to conversation about that.
Hi everyone, I am Pamela Altmaier. I am a civil rights investigator and the data manager for the Office of Equal Opportunity in Title IX. Similar to Hilly, I did my undergrad here, so I'm an alum of UM. I left to go get my master's and then came back with my family. I have 2 small children, so it's important to come back to Montana. My past is a little bit different than Alicia and Hilly. I don't have a law degree. My past classes in student affairs. And so I have worked in housing and then also with student conduct or community standards for 10 years before switching over to Title IX. So I come from kind of the university policy type of background where they have the legal perspective. So.
So as I mentioned, Title IX is an access statute. It is a statute that prohibits discrimination on the basis of sex in any educational setting that receives federal funding. And one of the things I'm pretty proud of at is that when people generally say the phrase Title IX, I think it has come to mean, at least here, efforts and identities and expectations that are far beyond what is actually contemplated by the law of Title IX. And again, I'm really proud of that. I recently heard, not proud of what I'm about to say, but I recently heard someone use the phrase Title IX as a verb, as in you've been Title IX. But I think that, so even as a topic for diverse youth today, thinking about how Title IX is understood and interpreted on our campus is important. So we are different than, I think, the norm, we being in that our policy, the discrimination, harassment, and retaliation policy, covers harm on the basis of 17 different protected class statuses. I'm not sure why some of them look so much bigger than the others. That's not intentional. But we have one policy and we have one set of procedures. So the students, employees, and affiliates of the institution are protected from harm on the basis of these protected class statuses. So again, we have one policy, one set of procedures, and then that in one office that administers this policy. So many institutions have a separate Title IX kind of office or structure from other forms of protected class harm. And then even more than that, have different offices designated for students and employees. And we sort of just do it all together. So our policy, the university's discrimination, harassment, and retaliation policy, brings together Title IX, this statute of Title IX, together with some of my other favorite civil rights laws, Title VII of the Civil Rights Act of 1964, which prohibits discrimination in employment on the basis of multiple protected class statuses, the ADA, the ADEA, the Montana Human Rights Act. And so they come together to form the basis of our policy. Not quite there yet. And one of the things I want to mention is our the law of Title IX changed quite a bit in 2020. I'm not sure if any of you remember, but under the previous administration, under Betsy DeVos, she released federal regulations that pretty fundamentally changed the way that Title IX is administered. And because we have one policy and one set of procedures, it changed the way that we receive and respond to reports of all protected class harm on this campus. And one of, and I just want to also mention that, that was a pretty difficult time. The regulations were released in May of 2020, and you might recall that was sort of the beginning of COVID. And then with an implementation date of August of 2020. So at that time, schools across the country had to figure out how they were going to pretty radically change how they administer this complicated law with a very short amount of time to do it. And so, we have come together as a university to build the university's EO Title IX hearing panel. And I can talk a little bit more about that here in a bit. But I want to mention that on June 22nd of 2022, the Biden administration issued a set of proposed regulations. We have just ended the notice and comment period, so we don't know what those regs are ultimately going to look like. But from 2020 to now, there's just been a lot of changes on the legal landscape, and I do think that nobody joins this kind of work because they don't care. So I think there are a lot of intelligent people who care very much, who are trying their best to meet the needs of higher ed, which are very complicated in a changing legal landscape. And so, I certainly don't want to come across as sort of believing that things are great or anything, but I do think that UM has done a pretty good job meeting the university's needs relative to the many legal challenges that we are facing. So, okay. Thank you. One of the bigger changes that occurred from 19 to 2020 with the new regulations is a change in jurisdiction. So adjudicatory jurisdiction refers to, what does the university have the obligation to address, and what is, and similarly with that obligation is like, what are we prohibited from addressing? And generally speaking, and again, we're going to get a little bit complicated because when I'm talking about Title IX, I'm talking about that as a specific section, as a specific law. But remember, at we apply the principles of Title IX to our entire discrimination, harassment, and retaliation policy. So certain types of harm are governed by different jurisdictional principles. So in general, for the university to have jurisdiction over harm experienced by one of our people, one of our members, there has to be a sufficient nexus between the conduct and the university. And we might get into that a little more, but the point that I really would like to make is that regardless of our jurisdiction, our adjudicatory jurisdiction, the university maintains a robust obligation or jurisdictional obligation to provide protective and supportive measures to people who have experienced harm that is contemplated by our policy. So what that means is even if we don't have jurisdiction to investigate and hold somebody accountable for a specific conduct, we have an obligation to make sure that our people can continue to go to school or go to work unencumbered by, but unencumbered by the harm that they've experienced to the greatest degree possible. So we're going to talk a little bit about what protective and supportive measures are. And I think this is a good moment to reemphasize what the purpose of Title IX is. We go back to the beginning, the purpose of Title IX is equal access. And so, while I believe that there is great merit in holding individuals accountable who have imposed harm that is prohibited by our discrimination and harassment policy, the priority is to make sure people can go to school and go to work. And so we have a whole series of protective and supportive measures that we can offer to people to enable their continued access. Do we have a slide about what the... And I just want to sort of say that I wish we could provide better, like more protective and supportive measures to people. Protective and supportive measures are designed to, again, enable people to continue to go to school and go to work. In the academic context, being assaulted or experiencing discrimination on the basis of race, that is not a disability, right? Being harmed is not a disability. And so an ADA accommodation is different than a Title IX protective and supportive measure. A Title IX protective and supportive measure should not fundamentally alter the nature of instruction. It should not undermine accreditation, but it should allow a person to the greatest extent possible to be able to continue to go to school. Some of our, protective and supportive measures include referrals to, our resources. Some of our friends from SARC are here right now. The Student Advocacy Resource Center, while Hilly and I are lawyers, we're not practicing attorneys for the university. That being said, we can provide information about how to report criminally and how to get a crime victim advocate. So I always start off my meetings by telling people I'm not a cop and I'm not the criminal justice system, but we will help students access, or employees, our people. We will help our people access the criminal justice system if they are interested, because much of the work that we do in our office also constitutes a crime. In terms of academic accommodations, we can work with faculty to help, or supervisors, so they're academic, but also workplace accommodations, to, things like delayed deadlines or, attendance flexibility in a workplace setting. That might be a change of supervisory structure, or just, a lot of requests that individuals not work with one another. We do safety planning. The mutual restrictions would include a mutual no contact directive, which is a directive from me usually, directing two individuals to cease unnecessary contact with one another. So it is somewhat equivalent to like an order of protection, except it's not criminal in nature. It's not enforceable by the cops, by the police. And it is not intended to be punitive either. So it is not intended to restrict any one person's access to school or to work, or otherwise result in a tangible adverse action, is the way we say that. But it is intended to sort of de-escalate conflict to allow people to continue to go to school and work. We can do area restrictions, which that one gets a little bit, that one is right probably on the line, but we sort of lead from the perspective that a person doesn't have an overriding right to contact with someone who doesn't want it. So, so if somebody can sort of demonstrate to me that their need to have contact at somebody or with someone is more important than that person's desire to have no contact, then we can sort of reevaluate. But no contact directives or area restrictions are not intended to be punitive. And then those are just the different offices that we make referrals to. We work really closely with our colleagues across campus because, most of the sort of conflicts or problems that we address in our office are human conflicts, which means they're complicated, which means, of course, there is often a safety component, a community standards component. If we're dealing with employees or working with employees, there's often an HR component. So it's school component with the deans. So we work closely with our colleagues. Okay, now I'm going to pass this to one of you two now.
So Alicia was just talking about supportive and protective measures and how we have a broader ability to provide that to students who have experienced any harm that's contemplated by our policy. And kind of one of the reasons that we are able to do that is that it's because supportive measures are non-punitive, meaning they don't have any adverse effect on the other person, and there is no process to kind of arrive at a supportive, well, that's not necessarily true, but I guess what I'm kind of trying to describe is that when there is the jurisdiction for somebody, when somebody comes and describes something to us and they want to file a formal complaint, and there is that nexus between what happened at the university and it falls under our policy, then there are, then those are the circumstances where we might have a complainant sign the formal complaint, and then there are certain situations where the Title IX coordinator can sign that formal complaint. And so what I'm going to just give you a sense of is what it looks like and what the process and the steps are in our office when somebody moves through the formal grievance proceedings. We don't have time to talk through kind of all of our policy provisions, but what we're talking about is when somebody comes in and it is describing and reporting that they've experienced some form of discrimination, harassment, or retaliation on the basis of the protected classes that we talked through. So the initial outreach is the first step that we take when we receive a report that somebody has experienced some form of protected class harm. And so if we get that through a mandatory reporter, or if we hear directly from a person that they believe that they have experienced that, then the first thing that we're going to do is send outreach to the identified complainant. And that may differ slightly based on how we get the information and what exactly that person is reportedly experiencing. And in that outreach, we invite the complainant to meet with our office. And so if the person who has reportedly experienced the harm wants to meet with our office, then we do that initial intake meeting. And in that meeting, Alicia or Pamela or I, or some combination of all of us, but generally Alicia does the intake meetings, will meet with the complainant to discuss what the reported conduct is, what the resolution options may be, and what the protective and supportive measures that our office can coordinate on their behalf. So I'm going to take you through, there are a lot of ways that these kind of jump into like off-ramp situations where maybe we don't have investigatory or adjudicatory jurisdiction based on what happened. I'm going to assume for what I'm talking about now that we do. So after we make the assessment that there is jurisdiction to have the complainant sign the formal complaint or the Title IX coordinator sign the formal complaint, then that document is prepared and it's defined very clearly in our policy for what sections are included in that document. And then it is issued, so it's sent out along with an investigation notice to both parties simultaneously. Once the investigation notice is sent out to the complainant and the respondent with that formal complaint, then the investigation has formally begun. And I'm going to assume that we're going to move through the investigation to the hearing, and Pamela is going to talk about how that may change in cases where informal resolution occurs, but I'm going to talk with you about the investigation and the hearing. And so at the investigation phase happens when an investigator is assigned, and I'm going to talk with you a little bit more in depth about what that looks like. And after that investigation concludes, then it goes to the hearing panel. And then if there'll either be a finding of responsibility or a non-finding of responsibility. If there's a finding of responsibility, there's a sanction. And regardless of finding, non-finding, and what the sanction is, the complainant and the respondent have the right to appeal that outcome. When we're talking about an investigation, a lot of what the very clearly prescribed steps that we have to take now are defined by what Alicia was talking about, the regulations in 2020 that were issued under the Department of Education at that time. And it is a very clearly prescribed, transparent process. And the idea behind those steps that we have to take is balancing complainant's right to bring the reported harm forward and to request that action be taken against our respondent's right to due process. And so what we do, Pamela and I are the primary investigators in our office, the only investigators in our office. How it generally goes is that we have an interview with the complainant. We have an interview with the respondent, and we along the way ask for people to identify witnesses who may have information that's relevant to the reported conduct. And then we interview witnesses, and we also gather relevant evidence along the way. That is all compiled first into what's called a preliminary investigation report, which is issued to the complainant and the respondent for their opportunity to review and provide feedback. And then we incorporate that feedback at our discretion, and then we gather any additional evidence, and then we compile it all into a final investigation report. That's kind of the quick overview. And that can understandably take quite a while because there are sort of built-in review periods. Sometimes we'll think we're done, and then somebody says something new happened, or look, there was this witness that I couldn't get a hold of or that you couldn't find, who contacts you, and then you're setting up another interview, writing another statement, having another review period. And so all of that process can sometimes take longer, I guess, than we would all like it to take, but necessarily. And then it culminates in that final investigation report, and the investigation phase is over. And really what the goal there is for us to just gather the information that's necessary for a hearing panel to be able to consider and guide their process in coming to either a finding or a non-finding of responsibility.
Yeah, I just wanted to mention that, unlike in civil or criminal court, where
like if you're in criminal court, the prosecutor, the state has the burden to prove harm, like, beyond a reasonable doubt. If you're in civil court, then the plaintiff has the burden to prove, to prove their harm by a preponderance of the evidence. In our structure, the individual who has reportedly experienced harm, the complainant, does not have the burden of proof, nor does the respondent. So we should probably have defined this. The respondent is the individual who's responding to a complaint. The complainant is the individual who has filed the formal complaint. Occasionally, I will sign a formal complaint on behalf of the institution, but I am not like personally stepping into the proverbial shoes of a complainant. It's a little bit different than that. But in our structure, neither the complainant nor the respondent bears the burden to prove that something happened or something did not happen. It is the university's obligation to investigate and set forth the facts. So that may sound, that may not sound distinct, but from like a legal perspective, it really is. So we are not asking a person who has experienced harm to come in and prove it. And we're not asking a respondent to prove that they did not do the thing that they are accused of doing. That's why this investigation process is so thorough, because it's a transfer of burden from parties onto the institution. And then we have to sort of balance that obligation to perform a thorough investigation with our competing obligation to resolve conflict promptly and equitably, and like with the competing principles of efficiency, safety, due process. So it's quite a bit to accomplish in a short amount of time. Yep.
And also, I think just stepping back from like some of the weeds of the investigatory processes, really distinguishing us from like the civil or criminal system or the police, or I think what is really helpful and what helped me when I first started doing this work is understanding kind of the limitations of like what the ultimate consequence could be for these proceedings. And so when we're in these like educational administrative processes that we're talking about, the worst consequence, if you were found responsible, is separation from the university. So if you're a student, that's expulsion. If you're an employee, that's termination. And I think sometimes that helps to understand like what is this distinct sort of process that we're in and what are the consequences. It's not jail, it's not a civil fine, it's not the things that we're maybe a little bit more used to when we hear about somebody bringing forth harm, alleging harm, and somebody responding to that.
That's why when we really think about primary purpose of Title IX is access, it's not accountability. Now, accountability is a really important aspect to this structure, but it is not the primary goal.
And so now that the investigatory phase has concluded, that final investigation report is handed over to this panel. And so what Alicia described the university having to do, Alicia foremost, between May of 2020 and August of 2020 is figure out how you are going to build this hearing panel. and in compliance with the new regulations. Something that, and I guess to be clear, the regulations don't require a panel, they require a hearing and a hearing officer. And so the University of Montana has kind of a unique panel that not all universities have, that is comprised of a student representative, a staff representative, a faculty representative, and then is chaired, has been chaired for our hearings by a local attorney. And that represents, I think, a kind of an important intentional desire for us to have input at that level from those different perspectives. Our policy provisions often require somebody to have experienced subjective harm, that they subjectively feel like what they experienced falls under our policy provision. And then also there's this objective component, like would a similar person in similar circumstances have also experienced that the same way. And so being able to have the input from a student, staff, and faculty along with that hearing chair allows for a kind of a more faceted understanding of what an objective perspective is. So that panel of 4 people participate in a live hearing, or they sit before the live hearing where the parties and witnesses can appear and provide testimony. It is over Zoom and it's live. There's a requirement under the regulations that it be live, but we are allowed to have them be remote, and that is the choice that the university has made, and that's kind of independent of COVID. In cases where after the hearing has concluded, the hearing panel makes a determination that the respondent is responsible for the alleged conduct, the hearing panel determines what the appropriate sanction is when the respondent is a student, but they don't if the respondent is an employee. They hand that over to the appropriate person to determine under employment policies or collective bargaining agreements. And then it's at that stage that either or both party is allowed to appeal the determination.
Okay, so I am going to finish off our presentation. I'm just going to check on time so I make sure I'm not holding you all too much longer, or longer than what I should be. So what Hilly just went over is our formal grievance procedures. So this is from the very beginning of when we receive a complaint, through the investigation, through the adjudication, and through that appeal phase. And so what we set up here is to talk about the different ways that we may be able to resolve complaints. And I just want to make sure that we're highlighting that formal grievance proceeding is only one of the options. It is not the only thing that we can do. So when Alicia introduced adjudicatory jurisdiction, if we don't have jurisdiction, it doesn't necessarily mean nothing can happen. Or if somebody, a complainant, because our process is complainant driven, doesn't want to go through that live hearing, it doesn't mean that's the only thing we can do. And so I want to kind of go through each of these other options with you all, just so that you know kind of some of the other things that our office does. So the way that we organize this slide is any of the options that are on this side of the slide means that a formal complaint was signed. So if we remember going back to the beginning of the presentation, a formal complaint is when the complainant wants to bring forth that complaint, the notice goes out to the parties. It's either signed by the complainant, or in some cases, Alicia has to sign those. So there's only 3 ways that we can resolve a case once the formal complaint is signed. So the first is going through that formal process. The next option is that we can informally resolve the case. And what that means is that the parties, so the complainant and the respondent, agree to certain terms that they want to be met. And then they're saying, if these terms are met, then we're not going to move forward with the formal process. We can get really creative with these. And so it sometimes helps with us being able to talk through what are different training opportunities, what are different educational meetings that we can have people meet with. We can put together permanent no contact directives that are not mutual. So we get rid of that mutual aspect of it. We've had people participate in the pedagogy project, which is a project for faculty members to learn from other faculty members about their teaching techniques and how to improve their teaching. We've had people go to counseling. So there's a lot of different options that we can do to try to provide that education and be able to make sure that we are taking the steps to try to prevent it from happening in the future and to resolve kind of the complaint and the conflict that's happening. There are times that we informally resolve a case where that separation from the institution happens. So if somebody, let's say an example is somebody is facing criminal charges and we're investigating, there are times where the person is willing to informally resolve the case and agree that they agree to expulsion from the institution and not have to go through the process. So we can be really creative in those processes. There are, based on the Title IX federal regulations, there are certain cases that we cannot informally resolve. And those cases are when a staff or faculty member harms a student and it's contemplated by Title IX, so it's sexual harassment. So in those cases, we're not allowed to informally resolve them. Another option that we can do is we can dismiss the case. The federal regulations have certain criteria where we have the discretion to dismiss it. And so that means if the complainant no longer wants to pursue the complaint, they can inform us and we have the discretion if we want to dismiss the case or if we want to proceed. If the respondent leaves the institution, so they just tell us like, I'm not going to be enrolled here anymore, I'm going to leave. We have the choice if we want to dismiss it at that point or if we want to pursue it. And then there are certain times where we have to dismiss the case. So that is when we know that there's no way that we would be able to find a finding of responsibility or that it doesn't meet our jurisdiction. So later on, we find out that there's some limitation to why it doesn't meet our jurisdiction or our policy. I think the really important part to talk about though is some of the things that we can do without the formal complaint. And so that is this side of the slide. So we introduce, when we talk to someone during those intakes or we're having conversations with people, we like to share that there's a lot of harm that happens on our campus and our society, and not all of it is going to be contemplated by our policy or meet the jurisdiction. And that doesn't mean that we're just going to send the student or the employee or the affiliate or whoever they are out the door and just be like, sorry, we can't do anything. We try our hardest to find some way to be able to support the person or to think about what we can do. Part of those is providing those protective and supportive measures that we talked about earlier, but also we have some of these other options that we can do. So one of those is consultations and coaching. So let's say hypothetically, there is a faculty member who is doing something that is pretty problematic, not necessarily reaching the threshold of severe, pervasive, and persistent. But we think it's really important to notify them that what they're doing is problematic and try to provide them some education so that they don't do it in the future or that we can fix kind of what's happening for the future. And so that's when we can do some of these consultations or coaching. Alicia sends an email to that faculty member, asks them to meet with her, and then she provides some education and overview of kind of what the complaint is, and then some recommendations. So, you know, you should probably really use rubrics when you're grading papers because it gets rid of the subjective opinion about the person when you're grading them or things like that, that we can try to support. I think the other really great thing that we do is it's not always individual. Sometimes we do some of those coachings or consultations with an entire department or academic college or something like that to make sure if we see that there is a hotspot on our campus of, hey, this group, there's something that's happening here, it's harming students or some of the employees, we can really focus in some of our interventions and do it as a departmental level, not just an individual level. Most of the time we do start talking to whoever's the head of that department or that unit and then work through what does that look like to provide that coaching or consultation to the group. We are on a lot of committees or we're involved with a lot of committees. So Hilly is the co-chair of the ADA committee. And so she helps lead those conversations. She responds to a lot of barrier reports. So if somebody, based on their disability, there's a barrier to their access to education or employment, those get reported to our office. And as a co-chair, Hilly helps lead that committee in responding to those and fixing those barriers. We're on a peace committee, which is looking at proactive and preventative ways to educate our community or to prevent harm from happening.
We consult very heavily with the bias response team because a lot of the time of what gets reported to the bias response team could be contemplated by our policy, or there is some sort of action that we can take in the protective and supportive measure aspect of it. And so we are on a lot of committees to be able to not only respond reactively after we receive reports, but also how does our office share our expertise and what we see from our reports in a more proactive way. Am I missing any committees? There's a lot. Okay.
Cleary, you.
Oh, yeah.
I spent a lot of time in HR.
And then, and then referrals and collaborations. So as Alicia was just introducing, we spend a lot of time with a lot of campus partners. Like I mentioned, sometimes people come to us because there's a lot of talk about Title IX on our campus. There's a lot of people who know about it because of mandatory reportership. And so sometimes people come to us and it's just not ours. It's something that we can't respond to or resolve. And instead of just saying, figure out where the next stop you should go and sending somebody to like, go from office to office to office, we try to make those referrals as best as possible to either send the summary of what they shared with us to the office so they can evaluate it under their process. Because to have somebody who's experienced harm tell us their whole story and experience the emotion of that and have to relive it and then go to the next office and share it all over again, and then the next office and share it all over again. We really try to take that away by summarizing it and referring it to the correct office and making sure that the person isn't having to guess who's the next one and then who's the next one. We know our partners pretty well to be able to be strategic on where that goes. So we collaborate on a case-by-case basis with a lot of offices. So again, the bias response team, human resources, the Office of Community Standards, Housing, SARC, did I say HR already? UMPD. So we work on a case-by-case basis with a lot, but we also have a rotating meeting with those groups. So we meet with them at least once a month to be able to talk about topics that we might work together on or specific cases. Again, we're trying to balance the reactive approach to things that are happening, but also think about, okay, so this case happened. This was a pretty difficult one. How do we improve for the next case that's going to be just as difficult or have similar situations happening or similar circumstances? And then the last thing is also we do a lot of trainings. So Alicia hosts a mandatory reportership training. I think it's once a month. And then also when we need to, or we see an area of concern, or we get a request, we can do some additional trainings. Alicia and Hilly just led an amazing training about going into the field and what does that look like and how do we support students while they're like out in rivers and woods and things like that, and not just like on our campus. How do we support those? We've gone to different athletic teams and given some very pointed trainings. We've gone to Greek houses. So our office tries as much as possible to provide trainings across our campus to increase our visibility, increase our understanding of our processes, and then also proactively provide that education. So just because we have a little bit of time, I am going to share some of our statistics. Yep.
I think Pamela's point regarding sort of sometimes harm is experienced, but it's not contemplated by our policy is a really good one. So, our policy is codifying legal definitions. So the legal definition of Title IX hostile environment sexual harassment is conduct that is rooted in sex, and we have defined sex at UM to include gender, gender expression, gender identity, sexual orientation, and physical attributes affiliated with sex, such as pregnancy and breastfeeding. So it's conduct rooted in sex as broadly defined that is sufficiently severe and pervasive and objectively offensive so as to interfere with a reasonable person's participation in a university program or activity. So that's like a pretty legal definition. Our definition of discriminatory harassment, which is harm that can occur on the basis of race or age or gender, any of those 17 protected class statuses, is conduct rooted in protected class that has the purpose or the effect of unreasonably interfering with a reasonable person's participation in a university program or activity. And all of those reasonablenesses are both subjective and objective. They're informed by case law. It's a fairly high standard, fortunately or not, right? Like, I'm not making a value statement there, but I think that it is true that there is so much harm that is experienced by people that is just not contemplated by those definitions I just shared. And it doesn't mean that harm doesn't matter or isn't affecting people. I quite unfortunately say all the time, there is a lot of racism that does not meet the definition of discrimination on the basis of race, or a lot of sexism that does not constitute sexual harassment or discrimination on the basis of sex. And so what we're trying to do as effectively as we can is improve people's experience at UM to the degree that we can outside of like the systems that are set up. Our role is a pretty formal role. We have really amazing people, two of them are here in the back, Jen and Selena, who do a ton of programming and trainings and workshops and provide support and advocacy for people. So making sure who have experienced identity-based harm. We sort of joke that like we're the lawyers and they're the therapists. Neither of those things are totally accurate, but that's kind of how it feels to me at least. And right, there's a real time and place for a lawyer and there's a real time and place for a therapist, and it's good that we work together. But that's why we collaborate so much, because it's important to us as individuals, of course, professionals, and as an office, that we're not telling, this isn't the harm Olympics. We're not telling people like, oh, your harm isn't good enough or bad enough, I should say, to warrant intervention. We want to be able to respond to people, to their experiences and to their needs, because in the end, Title IX is an access statute. And so whether or not their harm meets the legal definition as supplied by the law, the regs under Title IX, it is still affecting people. So
I'm just going to introduce this. I'm not going to spend a lot of time, just to point you to it, and you can go visit our website. A lot of the information we discussed today is in our website, but I also want to just talk about our annual statistics a little bit with you all and just point you to where it is. So as we mentioned, we have a mandatory reportership obligation for sex-based harm here. And then also we receive a lot of reports about all the other types of harm that is happening on our campus. Regardless, if somebody wants to move forward with any of those resolution options that I discussed, we make a record of it and we keep track of it, because we want to make sure that we do know if there is a specific person doing a pattern of behavior, or that there is that hotspot that we should do training at, or just to be able to really understand what the culture is and what's actually happening on our campus. And so if you are interested in exploring any of those statistics, my data management side and the very nerdy aspect of what I do is I make these annual reports. And so it is on our website. You just click on, where's my clicker? Annual reports or statistics over here, and then this page will pop up. You can click on each annual year. Sorry, it's not on this screen, so I'm trying to understand where the mouse is. Oh, yeah. You click on it. There you go. Then you will be able to see our annual report. I do want to tell you that I make this into percentages, not by number of reports, because if only one person experienced some type of harm, I don't want that to be easily identifiable. And so we do it by percentages. But you can look in here and you can see how many reports we've received for that academic year, who reported it, what is the identity or affiliation with the parties. So how many of our complaints are students versus staff versus faculty. You can look at what the policy breakdown is. So if the person wanted to move forward, what policies would be contemplated, what identities, and then what types of resolutions we do for each of our cases. And so I just want to point you there if you're ever interested in seeing some of the statistics that come out of our office. Of course, you can also go over to Clery and look at a lot of statistics with Clery. Know that we use different definitions when between the Clery statistics and ours, because clearly has to happen on our campus. Our reports don't necessarily have to happen on our campus. So they're not always going to equal the same number, but I think both can give you a pretty good picture of the culture and what's happening on our campus. So I just wanted to point that out to you all, just so you know some of the other efforts that we do and some of the things that are available to anybody who's interested. Well, thank you. I think we have like 5 minutes. I don't know if there's another session right after us, so we can probably answer some questions while I'm logging off if there are any pressing questions.
So the Supreme Court's decision for affirmative action have any effect on the Title IX office?
Love that question.
I mean, when I first started here, I was responsible for the affirmative action plan. I have since transferred that obligation to HR. And so they run affirmative action. I mean, the two cases that are pending in the Supreme Court are about admissions. And, you know, I can't recall a time that since I've been here where anybody has said that they did not get into the University of Montana on the basis of protected class. You know, and so because my understanding of the two, the Harvard and the North Carolina case they're about admissions, not about hiring. We do a lot of hiring work or people who assert that they either were not promoted or were not hired on the basis of protected class. But the Supreme Court cases are not about employment. So it's a really interesting question. I care quite a bit about it too, like personally. So I am also following it. Yeah, I think we'll see. A good question.
Kind of regardless of likely wouldn't change our policy, but I think like the debates that are happening, we feel pretty keenly in our office in terms of we were reflecting on just the 50th anniversary and like what does discrimination mean is a question that is answered very differently by different people. And so I think that we follow them because we definitely are experiencing those sorts of debates every day and the conversations that we're navigating with how people experience identity.
And our policy contemplates harm on the basis of sex, not on the basis of race, not on the basis of of color. And so, you know, I have certainly had people in my office who have reported that they've experienced discrimination because they have to read about white privilege as a white person. And so it's important that the law does not define which races, which sexes, which genders, which ages, well, sometimes on age, that depends, federally does, not in Montana, which version of those identities are protected and are not protected. And so when we think about, you know, sex, Title IX in 1972 was designed based on the legislative history to provide equal access to people who identified as women. But the law does not use the word women. It does not define sex. And so one of the changes in the proposed regs under Biden's proposed regs, is to affirmatively extend Title IX protection to all genders. And to me, it strikes me as a little bit ironic because we are right back to the beginning where there was really no articulation of gender or sex in the law. So now it is making clear, it's codifying our societal expectations 50 years later. Yeah, so I think those are very interesting conversations, and I'm really looking forward to seeing where the Biden administration's regs ultimately land. I think we're out of time. Thanks so much for coming. I really appreciate it.